Welcome. My name's Huw Davies. I'm a barrister at Farrar's building. This is our webinar on contribution indemnity and personal injury claims. It's a pretty dry talk, and I apologise for that. Go my scroll and work there. I'll be told by Kelly if it doesn't work. I used Chat AI and I inserted an instruction to draw an amusing picture for this particular talk, and this is what actually came up, which I suppose is good news for all of us worried that AI is going to take over the world. I'm not quite certain how is this relevant to contribution, but Chat GPT does seem to think that is how it should be represented. So I'm not going to argue with that. In relation to this talk, it's a rather broad topic, and no doubt within contribution claims themselves, there are going to be topics which could rightly have their own hour-long talk. I'm going to talk hopefully for about up to 55 minutes. And there is a Q&A tab at the top of my screen, which apparently people can put questions in. If there's time towards the end, I'll try and answer some of those questions that I'll put there. But if there isn't, please just drop me an email in Chambers. I'll try and get back to you if there's any general queries. Nothing, I think, too complicated. And otherwise, this copy of this PDF, this talk, actually, PowerPoint can be provided upon request. So, jumping straight in, what is a contribution claim, or what is contribution? It's helpfully defined under CPR and the glossary. It's a right of someone to recover from a third party all or part of the amount which he himself is liable to pay. And an indemnity is also defined as a right of someone to recover from a third party the whole amount which he himself is liable to pay. And it's an obvious point, but an indemnity is a form of contribution. And a contribution can be for a full or partial recovery, but of course an indemnity is going to be 100%. And in many respects, saying in your pleadings that you're seeking a full indemnity is probably a bit unnecessary, given indemnity is always going to be 100%. When might a defendant seek in contribution or indemnity from a third party? Well, it's in general terms after a settlement or compromise. That's subject to a 2-year limitation. I'll be looking at limitation periods a little bit later in this talk. Secondly, during proceedings, and there CPR 20.6 is going to be relevant. It sets out the procedure you have to follow out if you are going to make a contribution against a third party. What that, of course, provides for is that if a defendant's filed an acknowledgement service or a defence, they may make an additional claim for contribution or indemnity against the person who's already part of the proceedings by filing and serving on that party a notice containing a statement of a nature and grounds of additional claim. Additionally, the defendant may file and serve a notice without the court's permission if it's served with the defence, or if the additional claim for contribution or indemnity is against the party added to the claim later within 28 days after that party files their defence, or at any other time with the court's permission. So when you're serving a defence in this matter, if you serve the contribution along with that defence, you don't need the court's permission, but if you don't, then you will have to seek the court's permission. The practice direction to part 20.6 sets out when making an application what matters should be included in that application notice. And one of them, if it is not, obviously an application only has to be made if it's served after you've served a defence. An explanation for any relevant delay has to be provided in that application. You may ask, why might an application to join a party with a contribution claim be refused by a court? Well, it may well be that proceedings have progressed to such an extent that making an application for contribution may, for example, cause a trial to be lost, and a claimant may well object to the joining of a party in the contribution proceedings, because it may well cause the trial to have to be adjourned or lengthy further delay. And so the later time is spent making a contribution claim, the greater the chance that the court actually won't grant permission to make a particular contribution claim. That's during proceedings. And of course, contribution claims can be made after judgment. And that again is subject to a 2-year limitation period. What is the statutory basis for contribution? Well, it's set out under the Civil Liability Contribution Act 1978, Section 1.1, and that provides, subject to the following provisions of the section, any person liable in respect of any damage suffered by another person may recover contribution from any other person liable in respect of the same damage, whether jointly with him or otherwise. Broken down. Firstly, the claimant must have suffered damage. Now, that may sound like a stupid point, and it probably is such an obvious point, but in this day of low velocity impacts, fundamental dishonesty claims, it's perhaps not always a given that a claimant has in fact suffered damage. I mean, imagine a situation where, for example, an RTA is settled on the basis the claimant suffering injury, a passenger suffering injury, and it later transpires that that passenger wasn't in the vehicle at the time. A defendant insurer in that position might have some difficulties in making a contribution against another third-party car, for example, in that situation. They wouldn't be able to get around that by making a contribution. Secondly, the defendant must be liable in respect of the damages suffered by the claimant, and I'll be looking at that in a moment. Thirdly, the third party, that is the party where contribution will be sought, must be liable to the claimant in respect of the damage suffered by the claimant. And finally, the damage for which the defendant and third party are liable for must be the same damage. What does liability mean under the Act? Well, liability is liability which has been or could be established. I've moved my window there. Established against the defendant in an action in England and Wales on behalf of the claimant. It doesn't matter if the law is of a country outside England and Wales is applied. So, for example, there may have been a claim, a holiday, a travel accident occurring abroad, heard in the English courts, applying foreign law or foreign quantum law principles. That doesn't matter if the law that is applied in English courts is not that of England and Wales. A contribution claim can still be made. But conversely, in previous judgments in any part of the United Kingdom in proceedings brought by the claimant against a third party are conclusive. If the third party has been found not to have been negligent, then a defendant cannot seek contribution in later proceedings between the claimant and the defendant. So a claimant may have sued a party originally, they may have lost and then come against, sued the defendant. The defendant in those proceedings can't then subsequently join the original defendant because there has been a judgment brought against them and effectively dismissed in the court in the United Kingdom, not just England and Wales. However, the judgment against the original defendant must be in relation to a relevant issue. So negligence, for example, must have been determined that the defendant wasn't negligent, for example, rather than judgment being dismissed perhaps for procedural issues, for not obeying court orders or the equivalent, or for want of prosecution. So the second requirement, other than the claimant must have suffered damage, is that the defendant must be liable to the claimant in respect of damage suffered by the claimant, and that's set out under section 1.2. A person shall be entitled to recover contribution, notwithstanding that he has ceased to be liable in respect of the damage in question since the time when the damage occurred, provided that he was so liable immediately before he made or was ordered or agreed to make the payment in respect of which contribution is sought. What that means is that as long as the defendant was liable to the claimant immediately before the decision or agreement, it doesn't matter if the defendant subsequently is not legally liable. An example might be is that limitation may have expired after agreement had been reached between the parties, so after a 3-year personal injury limitation period. But if an agreement had been made within that period, then that will satisfy the requirements under the Act. And Section 4 provides that a person has made or agreed to make any payment in bona fide settlement or compromise of any claim made against him in respect of any damage shall be entitled to recover contribution in accordance with this section without regard to whether or not he himself is or ever was liable in respect to the damage provided. However, that he would have been liable, assuming that the factual basis of the claim against him could be established. This is very often quite a difficult concept to understand or explaining, certainly to clients. What this means requirement to bring contribution is between the original defendant and the claimant. There has to have been legal liability. So an ex gratia payment is not sufficient. There must be a legal basis for that liability. Secondly, the defendant in the main proceedings only has to demonstrate that the factual basis of the claim would have disclosed a reasonable cause of action against him, such as to make him liable in law to the claimant in respect of any damage. And this is often referred to as a deemed liability. An example of that may be a defendant might be a highways authority. The claimant might allege that there was a dangerous defect on the highway. Now, whether or not a defect is dangerous is very often, there's a degree of subjectivity. And sometimes it goes with how long is a piece of string. But a defendant's highway authority in that position would be entitled that the pleaded facts, if established, could have established liability against them, even if there was a contrary argument that the defect itself arguably wasn't dangerous. There doesn't have to be found a liability against the defendant, but effectively that the claim disclosed a reasonable cause of action against them. Thirdly, the liability does not have to have been admitted. So a defendant might enter settlement on a without prejudice basis, but that doesn't prevent that defendant from bringing subsequent contribution proceedings. If a compromise is reached before proceedings are issued, then the defendant will have to rely upon the factual basis the claim is presented to them by the claimant, in effect justifying why a compromise was reached. So in some respects, it might be a pre-action letter of claim or correspondence setting out the claimant's case. If proceedings have begun, the defendant can establish liability on the basis of the facts as set out in the statement of claim. The defendant, in relation to their requirement to be liable to the claimant, does not have to prove the claimant's case against them. Only that there's a demonstration of reasonable cause of action set out in the statement of claim. And the next requirement to make a contribution claim is that the third party must be liable to the claimant in respect of damage suffered by the claimant. As I've indicated, the defendant doesn't have to prove the claimant's claim against themselves under section 1.4, but the defendant must show that the third party would be liable to the claimant in respect of damage suffered. And that's usually done by establishing that the third party was negligent and that the same was causative of the claimant's loss. There's a recent claim, it was a few years ago now, Percy and Merriman White. It wasn't a personal injury claim, but involved a professional negligence claim brought against a firm of solicitors. They settled a claim of negligence against them and sought contribution from the barrister they had instructed to advise the client in that particular case. Effectively, the original claimant had fallen out with shareholders. There were various options in relation to what claims to have brought, and some advice was provided by counsel. And there's a professional negligence suit brought against the solicitors. And in relation to them joining the barrister in the contribution, what the Court of Appeal, reversing the finding at first instance, which certainly caused a bit of panic for barristers, let me tell you now. But when it was reversed by the Court of Appeal, what the Court of Appeal made clear is that section 1.4 of the 78 Act, by which liability was assumed, that was only with the liability of the party who claimed contribution, and it didn't, without more, touch upon whether the party against whom contribution sought was liable. So nothing in section 1.4 touched on whether the person from whom contribution was sought was negligent or otherwise in breach of duty, and whether that negligence or breach of duty was causative of the claimant's loss. So in bringing a contribution claim, the original defendant still has to establish that the third party was negligent or otherwise breach of duty. It might be statutory duty, and that caused or contributed to the claimant's loss. Another example, a case of Burnell and Flaherty. There, the defendant ran a petting zoo. There's an E. coli outbreak. A customer brought against them, and they sought contribution against the local authority. That contribution claim failed because the local authority did not owe any duty of care to the claimant in the original claim. And another example of this principle in practice, if we look at a highways claim, for example, a highway agency, the highway authority might have subcontractors doing up their road repairs, their statutory interventions, and that might govern how the agreement between them governs how that subcontractor carries out the work, whether or not work is done on defects of a certain height. The original claimant may have sued the highway authority because the defect was dangerous and considered dangerous, but that defect may have fallen below the intervention levels which the highway agency had agreed with the third-party contractor for intervention. And so the third-party contractor didn't act upon this defect because it wasn't part of the contractual agreement. In that situation, the highway agency would have difficulty, highway authority have difficulty in joining the subcontractor, because arguably that subcontractor wouldn't have owed a duty to the claimant who tripped and slipped in those circumstances. The duty is a statutory duty owned only by the highway authority. Final consideration is that the damage for which the defendant and the third party are liable for must be the same damage. In most personal injury claims, it's going to be easy to recognise what that damage is. it will probably relate to exactly the same accident. Matters become a little more complicated where there's a crossover between personal injury and clinical negligence. In the case of Rahman and Area Rose, here the claimant's employers had been negligent in relation to an assault which happened in the course of employment, and there was an injury suffered by the claimant to his eye. Went to hospital, had eye surgery, but as a result of negligence in the course of surgery to repair that eye injury, there was a further injury causing blindness to the eye. The employers were held partly responsible for those losses, which resulted from psychological symptoms, even though you had a supervening event, which is the negligent surgery. The contribution claim against trust in relation to the surgery that was carried out, and there was a division between the two effective defendants there in relation to who had responsibility for which particular injury suffered. And I think it was ultimately apportioned 3/4, 1/4 against the trust in relation to that. But there may have been some discrete injuries caused by the negligence of the employer and discrete injuries caused by the negligence of the hospital, and they would be dealt with separately in relation to an award of damages. That was also a case in a case called Webb and Barclays Bank and Portsmouth Hospitals NHS Trust. There, the bank was liable for a tripping accident that happened at the premises. Following surgery, however, there was amputation, and there it was in relation to the amputation, damages were split following the contribution proceedings 75-25 between the bank and the NHS Trust. But in relation to injuries resulting from the trip itself, not the amputation, that was only the responsibility of the bank itself. So there is some damage which was considered the same damage, but some damage which was considered to be different damage. And in contribution proceedings, it is only the same damage which contribution can be sought for. It's similar damage isn't enough, or damage which is materially the same isn't going to be enough either. How are contribution proceedings defended? Well, when you look at the requirements required for bringing a contribution proceedings, it rather indicates the type of defences that can be raised. First of all, the third party is entitled to argue that the settlement was not a bona fide settlement. There had been dishonesty or collusion. What does bona fide mean? Well, it was considered in the Law Commission report on contribution way back in 1977. They indicated that it was important that the compromise should not be a sham, that it should be genuine, and that one test of genuineness would be that it should confer a benefit on the plaintiff, which he would have to bring into account in the assessment of the damages recoverable from the other defendant. Other relevant matters would be the amount of settlement and the circumstances in which it was made. And if it was made by one defendant behind the other's back, or if it involved accepting liability for an extravagant amount, it would no doubt be regarded by the judge with suspicion. They wanted to exclude collusive or otherwise corrupt or dishonest compromise, but they didn't consider it be appropriate to provide a detailed definition of what should amount to bona fide compromise. And then rather, hopefully it stated this is something which should present no difficulty to the courts. Dishonesty or collusion obviously is more easy, perhaps more difficult to prove, but if it is established, that would be a defence. A second way of defending contribution is that the defendant, the original defendant, wasn't in fact liable to the claimant. So they may have conceded liability on where there was no reason for them to have done so. Thirdly, the third party is not liable to the claimant, which of course is very often the main argument which is raised. That may be because it said they owed no duty of care to the claimant. That might be, as I said, a third party contractor in a trip and slip claim. Or they weren't negligent if a duty was owed. Or finally, that such negligence was not causative of any injury or damage. Thirdly, it can be argued that the settlement was too much, or that certain heads were not recoverable in law via the claimant from the defendant. And now the Section 1 of the Act, it's concerned with liability and not quantum. So a person from whom contribution is sought is always entitled to argue that certain heads of loss were either irrecoverable in law or that the settlement was just excessive. It may be that the claimant had overstated their case. So it is always open for a contribution defendant to argue that any compromise was for an excessive amount. It is, of course, much more difficult, if not impossible, to make that argument if there has been a previous judgment in relation to the matter for which contribution is being sought. And limitation is, of course, always going to be a valid defence. Looking at limitation, under Section 10 of the Limitation Act, 1980, it provides that no action for recovery of contribution shall be brought after the expiration of 2 years. And then we have a number of scenarios. Firstly, the date of a judgment or arbitration award made in relation to the damage sustained by the claimant. Importantly, if quantum is decided at a later date from liability, then the relevant date is when quantum is determined. There might be a split trial on liability. Once against the original defendant liability has been established, whether by admission or by a court order, that doesn't start the contribution clock ticking. It is only when quantum is decided at the later date that timer starts ticking. That also would apply in relation to a disposal hearing. If, for example, no defence is served, you have a standard disposal hearing and an amount is determined by the court. It's at that time, not when judgment is entered. It is when the actual quantum has been quantified by the court or agreed between the parties. The Act provides that no account is to be taken of any judgment or award given or made on appeal, insofar as it varies the amount of damages awarded against the person in question. So a case might go to appeal, quantum might be reduced, but that doesn't mean that the clock hasn't started running, and it doesn't mean that the clock is paused. Matters, of course, different if the appeal is entirely successful, but then there wouldn't have been any award made if entirely successful. But if on appeal the amount is actually reduced of a quantum judgment, doesn't mean that causes to restart or pause the countdown, the 2-year countdown for bringing the claim. The third situation, when the defendant makes a payment in compensation for the damage or when the defendant agrees to make a payment. Now, Section 10(4) the Limitation Act makes quite clear that it is the relevant date is the earliest of the two. So if you're at a joint settlement meeting and you agree to an overall settlement figure, but you're drawing up the order and send it in consent order to the court, it is the time of the agreement rather than the consent order itself. So be careful if you are going to make a contribution proceedings or seek contribution that the clock hasn't run out. That was a case in Knight and Rochdale Trust back in 2004. Here, it was there had been an agreement to settle the original claimant's claim, and there had been a much later consent order, and an issue rose as to which was the appropriate date, and there it was considered it was the timing of the original agreement when the 2-year period started running, and that therefore the contribution claim, which was brought within 2 years of the consent order, but not within the actual agreement between the parties, it was found that it was being brought out of time of the limitation was successful. Where the amount of damages is agreed on one date, but the amount of costs is not agreed until later, time runs when the damage is agreed, and that's because Section 10.4 is concerned with damages and not with costs. So again, there might be toing and froing between the parties trying to agree the level of costs between the parties, but ultimately once damages are agreed, that's when the clock starts running. Can limitation contribution periods be extended? Well, Section 10.5 provides that Section 33 of the 1980 Act, that's where the court has a discretion to extend limitation in relation to personal injury claims. It doesn't apply to Section 10. What that means is that the court has no discretion to extend the period of limitation for contribution action, even if it is a personal injury action for which contribution is being sought. So that 2-year period is going to be strict. There are two slight modifications to that. Firstly, if the defendant is under a disability, then the limitation expires 2 years after they cease to be under a disability or die, whichever occurs first. And then secondly, when an action is based upon fraud of the third party or a fact relevant to the defendant's right of action has been deliberately concealed by the third party, or the action is for relief from consequences of a mistake, time only runs when fraud, concealment, or mistake was or could have been discovered with reasonable diligence. What about the relevance of a limitation period between the claimant and the third party? Obviously, the claimant and the original defendant in a PI action has to bring a claim within 3 years. What happens if the claim for contribution is brought after 3 years have elapsed since the accident? Well, Section 1.3 says a person shall be liable to make contribution, notwithstanding that he has ceased to be liable in respect to the damage in question since the time when the damage occurred, unless he ceased to be liable by virtue of the expiry of a period of limitation or prescription, which extinguished the right on which the claim against him in respect of the damage was based. In relation to personal injury, what this means is that it is only if by reason of limitation that the claimant's claim would be extinguished that the contribution claim will fail, but most periods of limitation in tort merely bar the remedy, not the right to the remedy. And so in the case of personal injury, the claimant may bring a claim against the defendant on the cusp of limitation. The defendant may settle on the door of the hearing many years later, but a contribution claim can be brought, let's say 2 years later, even though the claimant's injury occurred nearly 5 years previously. If a contribution claim has been brought, goes before the court, how does the court apportion between it may be two defendants, additional party, or it might be in separate proceedings to original claim? Well, Section 2.1 provides that the amount of contribution recoverable shall be such as may be found by the court to be just and equitable, having regard to the extent to that person's responsibility for the damage in question. What that means, first of all, the contribution cannot be greater than the liability to the claimant. So a defendant cannot claim against a third party more than their liability to the claimant. The contribution can range from 0 to 100%, which is a full indemnity. But ultimately, it is a matter of discretion. What's been said, it is just and equitable to take into account both the seriousness of the respective parties' faults and their causative relevance. A more serious fault having less causative impact on the plaintiff's damage may represent an equivalent. Case of Hughes and Williams was this was where a child suffered very significant injuries in a car accident. The mother was joined as in contribution by the insurer of the liable defendant, and on the basis that she hadn't properly used a proper appropriate car seat for her child's age and weight. And there the contribution was considered to be 25% on the basis that the child was injured more severely than would have been the case had an appropriate car seat been used. And that's a clear example of the court weighing up all the factors and considering what is just and equitable. It makes it a little bit difficult to predict things, given the wide discretion. But it is a little bit like issues of contributing negligence themselves or claimants very often as well. As indicated, it can be 100% contribution, and certainly I have been in cases where, again, a higher authority have entirely subcontracted works to an independent contractor, and there has been 100% contribution in light of breaches of that independent contractor. But of course, that has to satisfy the requirement that that independent contractor is, of course, liable to the original claimant. So you can get 100% contribution. And I've already mentioned the Webb and Barclays Bank there in relation to the amputation of a leg following a trip and clinical negligence. The court apportioned 75-25 in favour of the bank, finding that the bulk of blame for the subsequent amputation rested with the trust. Mesothelioma cases, some of you may be dealing industrial diseases, particularly mesothelioma cases, and of course you have the rather unusual situation under the Compensation Act. Section 3.3 provides a responsible person can be liable for the whole of the damage, despite there being other people who exposed the original claimant to asbestos, but the party can still claim contribution, and there's specific provision under Section 3.4 for how contribution is to be determined, and that sets out under Section 4 there, looking at different responsible persons for asbestos exposure. The court shall have regard to relative length of the periods of exposure for which each was responsible, but it doesn't apply if there's been agreement to apportion it on a certain basis, or the court thinks that there's another basis for determined contributions. But effectively, that provides more guidance for how a court determines contribution rather than the rather broad, just and equitable jurisdiction for other matters. Costs. What about costs of bringing a contribution proceeding? Because the Act is about contribution for damages and is largely silent about the question of costs. Well, under the Senior Courts Act and County Courts Act, the court does have a discretion and may order a party liable to make a contribution to a party that they pay costs. And those costs may also give rise to a contribution under the 1970 Act. Certainly, in my experience, judges are not unwilling to make costs order when successful contribution claims have been brought. Indemnities. This is and over time, I know some of you might be specifically listening in relation to contractual indemnities. Under the Act, does not preclude a party from claiming under an express or implied contractual right to indemnity or terms that regulate or exclude contributions. And that's set out in section 7.3. And there, nothing in the Act, the 78th Act, will affect any express or implied contractual or other right to indemnity or any express contractual provision regulating or excluding contribution, which would be enforceable apart from the Act. This isn't an appropriate junction to go into details of contractual interpretation in relation to indemnity clauses. In general speaking, if you have a very strong indemnity clause within a contract, very often you will be inviting a third party to take over conduct of a claim in any event. But the principles of contractual interpretation will apply to such contractual terms. So there will be a consideration of the commercial context of the contract when considering of an indemnity, and there will be application of the contra preferentum rule to interpreting exculpatory contractual terms, etc. There may be, for example, everything will depend on the particular wording of the indemnity clause. That will go towards things such as recoverability of costs prior to perhaps a claim for indemnity having been brought. And very often that will be governed by principles of reasonableness anyway, whether implied or expressed within that indemnity clause. But a contractual indemnity is a separate matter than normal claim for contribution under the Act, and it is not restricted by the Act, that contractual indemnity. What restricts it are laws of contract and interpretation of those contractual terms. Briefly, practical considerations as to timing of contribution proceedings. How strong is the claimant's claim against the defendant? Joining a third party during proceedings places that party who joined them at risk of costs. That was Wagoneer. The case of Wagoneer made that clear. So a defendant may want to consider just how weak the claim is against either themselves or indeed the third party before joining a third party, because they are going to be likely to be liable for the cost of the third party, because it's not going to be quox protected should the claim fail. The changes to Part 36 offers and ability to set off, defendants can set off against damages of claimants under recent quox reforms in relation to that. Probably means claimants are going to be less likely to want to join third parties simply because defendants in a defence may well have intimated that blame lies with that particular defendant. In the past, it was always, you could always trust, when there weren't concerns about costs, a rather broad number of defendants being joined if intimation by one particular defendant. And that meant that that defendant didn't have to make contribution proceedings because the party they're going to make contribution was already part of litigation. But that seems to me to be less likely to be the case when there are specific cost concerns, even in light of quocs. Another obvious consideration is just how strong is the claim against the third party. Sometimes it is a tactic to join third parties because as a negotiating tool, to have them within party litigation means they're probably more likely to settle rather than pursuing them after litigation where it may be more difficult. Another factor is just how much is a contested hearing against the claimant going to cost. An early compromise is going to significantly reduce damages and costs, and that may well be worth not joining another party at an early stage if the claim can be dealt with at an earlier stage. And the risks of not being successful against a third party may well be outweighed by the cost saving to a defendant for contribution, because contributions are never or very unlikely going to be 100% recovery unless there's a contractual term to that effect. How cooperative is a third party likely to be in the absence of litigation? Sometimes it may well be that documents are needed from a third party to defend a claim against a claimant, and that might not be forthcoming. It might be easier to have them as part of the claim itself. It may also make them more likely to chip in, perhaps compromise as well. So that is a factor. And finally, and perhaps most importantly, how cooperative is a claimant going to be in a later claim against a third party if the claimant's evidence is going to be needed to establish against that third party? In the Merriman case, that was the barrister who'd been joined in relation to a professional negligence claim. Evidence had not been given by the claimant in relation to that contribution claim. And that was a fundamental problem for the solicitors suing the barrister, and the Court of Appeal had considered that to be a fatal lacuna. If you are going to settle a case, that should be effectively be done on the basis of ensuring the claimant's cooperation, both in providing evidence, but also, if necessary, appearing at court, because you still have to establish the negligence causation against the third party, and that in many respects there is an evidential requirement. If you suspect the claimant's not going to cooperate or is going to be difficult, then getting the third party in to proceedings is, of course, an obvious way around that, because the claimant won't be able not to progress their case. And the first defendant will have the benefit, therefore, of not having to need to call them if matters are compromised. So that's another factor as to whether you make contribution proceedings during the original proceedings or you wait until there has been a settlement. Before this seminar, someone kindly sent a note talking about implied undertakings and CPR 31.22. I briefly mentioned getting claimants to cooperate in a contribution claim, but there is, of course, the problem is, how do you prove a contribution claim? What evidence are you entitled to use if there has been proceedings against the original, brought by the original claimant? Those have ended. Are you entitled to use those documents, many of which will be relevant? Well, the general principle of common law is that of implied undertakings, that is private information obtained under compulsory powers cannot be used for purposes other than those for which they were conferred. This has a basis now under the CPR 31.22. This provides that a party to whom a document has been disclosed may use a document only for the purposes of the proceedings in which it's disclosed, except where the document has been read to or by the court, or referred to at a hearing which has been held in public. Secondly, the court gives permission. Or finally, the party who discloses the document and the person to whom the document belongs agree. If those requirements A and C, that is, it hasn't been effectively read in open court, or there hasn't been consent by the claimant, and in addition, the person to whom the document belongs, they may not be the same person, then an application to the court has to be made for permission to rely upon those particular documents. And the same rule effectively applies for witness statements served during proceedings, which very often may form an important plank in a contribution claim itself. In that situation, an application would have to be made to the court for permission to rely upon it. The general principles which the court apply is that the court will not release or modify implied undertakings given on discovery, save in special circumstances, and where the release or modification will not occasion injustice to the person given discovery. So applications have to be made for permission to rely upon those. It seems to me that if you have a valid contribution claim and that certain evidence is required to establish that, then a court is going to be very broadly sympathetic to such an application. And it is difficult to see why claimants in such situations would necessarily object to that. Medical records are a different matter. It's understandable why claimants may well not want to disclose medical records to third parties seemingly unconnected with their accident. But an important factor to the court is, of course, there has to have been a basis that that third party would have been liable to the claimant in any event. And in matters such as clinical negligence, very often the party where its contribution is sought from may well have been that person who provided negligent medical treatment for which they will already therefore have knowledge of the claimant's medical conditions, and in that circumstance it's difficult to see what prejudice would be suffered by the claimant in such circumstances. But CPR 31.22 and implied undertakings themselves could well take up a never very long hour. So that's a very brief reminder that there are implied undertakings and specifically provided under the CPR. And if in doubt, seek permission from the court. Well, there we are. Final picture. Again, don't ask me why. But I asked ChatGPT for an appropriate picture for the ending of this seminar, and that is what was provided. So I think we are all going to be safe in the future. Many thanks. So looking at the Q&As, I don't think we now have time. Chris, I will give you a buzz. Anonymous, when would damage not be deemed to be the same damage? I think I've given examples of that in clinical negligence and in personal injury claims. So a broken ankle leading to an amputated foot, that may well be considered to be a different damage. Certainly the original break may be considered different to the amputated foot. Limitation runs from the date when Part 36 offer is made or when the claimant accepts it. I think it's when the claimant accepts it. It's not the offer, it is the acceptance. It is when quantum is agreed. Peter, so thank you for that question. The final one, if claimant's claim is settled by one of number of defendants, all of whom deny liability, all defendants have issued contribution notices. Any reason why a contribution issue cannot be tried as standalone issue, i.e. which defendant pays and how much. Whoever sent me that, drop me an email and I'll get back to you on that. I think my time is up. And on that cliffhanger, thank you very much for joining me. And I hope it was of some help.